Welcome back to Agent After Hours. I am here with Ann Taylor on another episode of What If, and today we're saying, what if you get a call to go on a listing presentation, and you look up on county records, because you did your due diligence and looked ahead of time, and find that the person that is on county records, or the deed, is not in fact the person that you called, or that called you to come out and list their home.
Yeah. So licensing laws will require that you get all sorts of approvals and authorizations from the owner of the property. So it's important that you know that you're working with the owner. So you're already in a really good position that you bothered to pull the deed and the county record information. Please don't skip that step. It's such an easy, quick step. Please don't skip that step. And so now I see on the records that Tyler Morton owns the property, and yet Heath Morton shows up. Who's this guy? Is this your nickname? Is this an alias?
It's that jerk brother of mine.
Is it your son? Is it your... So people will pretty quickly fill in the gaps on who they are. Usually it's not somebody that's a total fraudster. That can happen, but that's not generally the situation. Usually the situation is it's somebody acting on somebody else's behalf. So Heath is now acting on behalf of Tyler because he's his power of attorney.
Right.
Well, you want to take a look at that power of attorney and make sure that it, in fact, is valid, properly executed, names Heath as power of attorney for Tyler and for the purpose of selling real estate. We look at those things all the time. We're happy to assist with that.
I was going to say, I'm going to send it to Ann Taylor at Eminent Title to review it.
That's right. The other thing where it could be a legitimate mistake is that this person is acting, and it says Tyler Morton, trustee. So I say,
which I just had come up as well, and
yes,
you said you're going to need a memo of title?
We're going to need a memo of trust.
Memo of trust,
but
sorry.
That memo of trust is like an abbreviated summary of certain provisions of the trust that ultimately is what goes on the public record, or it can be an affidavit or certificate of trust, different things that it's called, with different pieces of information. But nonetheless, somebody needs to lay eyes on that trust document. Again, we're happy to do that for you, but it's important that you know to ask. You see trustee after their name, because there's plenty of situations where a trustee does not have authority to sell property. Where I've most commonly seen that is actually second or subsequent marriages. And so one person who has owned this property as trustee of his or her trust names their now spouse as the successor trustee, but quite frankly, the beneficiaries of the trust are the children or other heirs.
Right.
And they don't want the spouse to be able to sell off all of the assets and keep the money for themselves. It's defeating the purpose of the trust. So they have restricted certain things within the context of the trust. And unless somebody lays eyes on it, you don't know that. It's eventually going to come up with the title company, but you don't want that to come up after you've been under contract for 25 days and everybody else has laid a lot of time and money into this transaction, because there's nothing but a bunch of liability in that for you. Same thing goes if you see that it's Happy Homes LLC and there's Tyler Morton. Tyler, what's your relationship to this LLC?
Right.
Oh, it's my LLC. Any other members? Do you have authority to sign? Are you the manager? You don't know unless you look at the operating documents, the operating agreement for that LLC.
Well, in this particular scenario, it appears that the LLC still owns it, and the owner, quote unquote, believes that they purchased it from this LLC in 2018.
Oh boy. So it could be something as simple as an error in the public record. So we're telling you to look online and check those records, and now in the same breath almost, I'm telling you it could be wrong. That happens. It happens, but it's not the commonplace. But that's a moment where you're now getting additional information. It really is important to dig in.
All indications led to that it's an unrecorded land contract, or that it's a lease purchase, and the client simply did not know what they were signing.
They didn't know what they were signing.
Because they did not close with the title company.
Yep. And we see that all too often. And so now you've got someone who they themselves may want to turn around and sell it.
Yep.
This person who thinks they've been buying it for a number of years, and they didn't sign with the proper party. They didn't have a title search done. They didn't have the right documentation. It can impact their ability certainly to sell, but also their ability to get financing at that point in time. You can't do anything about that except for you can know that if the person who legitimately is on the county record is the owner, and you're not working with that person, you're not going to have any authority to list the property even if there is proper backup documentation to show that that person who thinks they've been buying it has some rights or is due some equity in the property, you still have to get all of your authorizations and listing agreements and approvals from the actual title owner under Ohio licensing law.
So do your due diligence and do a quick look on county records to find out if you are indeed working with the owner. It could be incorrect, at which point you would need some additional paperwork and certainly ask for it when it comes time.
Yes.
And send it to Ann.
And send it to me. I'll tell you that the majority of issues that we come across as a title company could have been resolved if somebody had just even pulled the deed or even the tax information online, and they would have known right out of the gate, you're not working with the right parties, or maybe it shows a husband and wife, and why do you only have the Mrs. here? Perhaps Mr. has passed. Is it a simple matter of a survivorship affidavit that can be handled at closing, or did an estate need to be probated, and now we're going to have some delays before we can get to close?
Great info. Thanks, Ann.
Thank you.
We'll see you guys next time.